because lawyers for one side or the other invited you or directed you to be here, then you should definitely stay on, and we'll move through this. Let me tell you where I think we are procedurally, and then I will hear from Mr. Tripp and Mr. Obaseki if you agree that's where we are procedurally. And then this is a bench trial, I think, but it's only on the counterclaims. And so I'll turn to Mr. Obaseki for whatever we're doing next. Let me just write down one more thing. All right. So Cityside Law filed suit to collect unpaid condo COA assessments, as well as to foreclose on the lien that is created by the unpaid assessments. When Mr. Rowland responded, he did so pro se initially. His answer included a counterclaim for damages. We need to work through that because since then, Mr. Rowland has retained counsel for Community Development and Investments, LLC. We have litigated a motion for summary judgment filed by counsel for Cityside Lofts. I've entered that order. That did not resolve the entire case. It resolved Cityside Lofts claims, but the counterclaim remains. I thought maybe there'd be some type of settlement because counsel for Community Development and Investments pointed out in their response to the motion for summary judgment, there's an offset of sorts. That's not a reason to deny summary judgment, but Mr. Rowland has made a claim that he has suffered damages because of work that either did not occur or did not occur in a proper way to either his unit or space near his unit. And that's what remains, is figuring out were there damages, and if so, to what extent. So that's what I think we're working through today. Mr. Tripp, is that your understanding of where we are procedurally?
Yes, Your Honor.
Okay. Mr. Obaseki, you agree?
That's correct, Your Honor.
All right. Then I know there was a witness and then maybe an objection to a witness. Do we need to work through that now, or Mr. Tripp, are you comfortable letting counsel for Community Development and Investments move forward and you'll lodge an objection if that becomes appropriate?
Mr. Obaseki, do you still intend to call that witness that you notified us of yesterday evening?
I do actually. I'm trying to get her on the call as we speak. She's actually traveling and on the West Coast, so there's a time difference there. There's also the issue of a sort of pending settlement offer. I'm not sure if Mr. Tripp at this point has had an opportunity to speak to everyone on the board or his client. But we submitted that a little earlier today and we're just sort of waiting to hear back.
Okay. Well, that may happen in the background, but I'm here for the trial, and either we're going forward with that now or we're not, and you're withdrawing your claim, Mr. Obaseki. But I'm ready, if you're ready, to either call your first witness, or if you want to give me a brief thumbnail as to what the claim is and why you think your client's entitled to judgment in his favor, that's fine. You don't have to give an opening. It's a bench trial, but I won't preclude it if there's something you want to say.
Yes, Your Honor, thank you. I'll do a brief opening. Essentially, as Your Honor noted, this is a sort of simple case in terms of the counterclaim being the only thing outstanding. The issue is exactly what Your Honor noted, that the condo association has failed to do repairs, we believe necessary repairs, such that it has impacted our client to the point that his dwelling, his unit 217, is essentially uninhabitable. He started complaining about Jockey pump in 2015 to Cityside Lofts. At the time, I believe they were had another management company, Beacon, who was representing them. It got to the point that he even had to submit a letter from an attorney to try to get the matter resolved because there was just no movement on it. The Jockey pump noise around his unit is significant, such that it's louder than loud music. And not only is it loud, it vibrates. At some point in 2015, some portion of the jockey pump presumably was moved from the hallway where it resided to underneath a mechanical closet, which is directly underneath our client's unit. So instead of being loud and vibrating his kitchen, it's now being loud and vibrating his bedroom. He did have a tenant in that location for some time, but the tenant had to leave. It's just not something that anybody would take. There had been some conversation and communication back and forth about repairs. The condo association essentially said that it would cost too much. They tried to do some workarounds, but nothing really fixed it. And it's just gotten worse over the years. And it's to the point now that Mr. Rowland can't put any tenants in there. He tried to live there himself very briefly because he has 2 units in the complex. But once he was there, he also realized nobody could live there. It's just entirely too loud. It's an incredible nuisance. And we've asked the condo association on multiple occasions over multiple years to fix it, and they've refused to do so. And that's essentially the claim that we have present for the court.
Okay. One question about that, and then I'll ask questions of witnesses if I need more. Was there not also a water damage issue, or it's all the jockey pump, or the jockey pump is both noise and water damage?
No, there was a separate water damage issue. The roof of the complex apparently needed to be repaired. That's another ongoing issue that's been happening for years. It's my understanding, and there'll be testimony, I'm sure, regarding the condo association has attempted to make repairs over 4 phases. Unfortunately, the condo where Mr. Rowland resides has not yet been repaired. He did have some damages in, I believe it was 2017, where he had to file an insurance claim. The insurance claim was paid, but he did, of course, have to come out of pocket deductible. This, of course, is another ongoing issue that the condo association is well aware of and hasn't been resolved yet.
Okay, great. Well, thank you for that. Mr. Tripp, do you want to provide an overview now, or do you want to reserve for whether you're going to present your case in chief, or you're good to go with Mr. Obaseki calling his first witness?
I'm good to go. I'll reserve my case
Okay.
for the rebuttal case.
All right. Mr. Obaseki, if you call your first witness.
Yes, our first witness will be Michael Rowland.
All right. Mr. Rowland, I'm going to spotlight you so that everyone sees you during your testimony. What I need you to do is look to, you should see a deputy at a screen that says podium on it. She's going to swear you in. Once you're under oath, then Mr. Obaseki can start with his direct exam.
You can raise your right hand for me. Do you swear or affirm that the testimony given in this courtroom today will be the truth, the whole truth, nothing but the truth, so help you?
I do.
You can lower your hand and state and spell your first and last name for the record.
Micah Rowland, MICAHROWLAND.
Thank you, Mr. Rowland. I want to start briefly. Mr. Rowland, how are you, if at all, connected to Community Development and Investments LLC?
I'm the founder and creator of Community Development and Investment LLC.
Okay. And are you the sole member of that company?
Yes.
Okay. And in being the sole member of that company, I presume that you had to go through the process of certifying through the Secretary of State's and things of that nature. Is that correct?
Yes.
Okay. And of course, you also have to register your company annually and things of that nature. Is that correct?
Yes, sir.
Okay. And did you purchase a condo at the Cityside Lofts in the name of Community Development Investments LLC?
Yes, I did.
Okay. And so the unit that you purchased, what is the unit number?
217.
And do you recall what year you purchased that condo unit?
2012.
Okay. And so in 2012, did you live in that condo unit?
I did. I lived there temporarily.
I'm sorry, say that one more time.
Yes, I did.
Okay. And at the time that you moved in, were you aware of the pump that sits outside of that residence?
No, well, no, I didn't pay attention to it. No, I'm gonna say no.
Okay, but you did see it. It's there. It's clearly visible. Is that correct?
Right. Yes.
Okay. Just a second. Sorry. And so, how long exactly did you live there?
Approximately, I'm gonna say about a year and maybe like a year and a couple of months.
Okay. And after a year and a couple of months, why did you stop living at the residence?
I wanted to be able to rent it out to another person.
Okay. And did you actually do that?
I did. Yes.
And so you had a tenant at that residence. How long did you have a tenant for?
For approximately 6 years, five to 6 years.
Okay. So from 2014 to what, 2019 or 2020, which was it?
2020. The end of 2020.
Okay. And at some point, it appears that you became aware of some issues with the Jockey pump. Is that correct?
Yes.
How is that you became aware of those issues?
Well, I received a text message about there was a noise. Going
Objection,
on.
Your Honor, hearsay.
Your Honor, I'd ask that he not go into the content of what the text message was, but just simply how he was notified of the issue.
I received a complaint from Danielle about the noise.
A complaint from whom?
Danielle, the tenant.
Oh, from your tenant. Okay, got it. And how you mentioned that, was this the same tenant for the 5 to 6 years, or was it different tenants?
Same tenant for the 5 to 6 years.
Okay, so when in that 5 to 6 year window, roughly, did you receive this complaint?
It was a little bit after I moved out. It was a little bit after I moved out. It was within the year of 2014. I mean, I wasn't aware of what it was, and in the beginning, it wasn't happening a lot. So I went over there to find out what it is. So it was within that first year, but initially I didn't hear it until one day I was actually over there to hear it. And so it was within that first 2014 year.
Okay.
Thank you. And so after you started to hear these complaints, did you notify the board?
I did. I immediately contacted the board. Yes, probably yes.
Okay, and how did you notify them exactly?
Via email. I sent an email to the Beacon management and let them and so that they can. I mean, I didn't know what it was, so Beacon management. So I sent the email to Beacon management.
Okay. And did you ever receive any response or anything from the board regarding your complaints?
Initially, not much. Not in the beginning, and then I think more people started complaining about it, and I received.
Objection, Your Honor, hearsay.
So, Mr. Rowland, you need to make sure, unless Mr. Obaseki asks you specifically, what did so-and-so say or what did they write? Try not to get into what other people were saying. You can talk about what you saw, what you did, what you wrote, but not necessarily what other people did. There may be times where that's okay, but Mr. Obaseki is going to need to ask you specifically, well, what did that person say? So Mr. Tripp will have a chance to say, I object, I can rule on it, and we'll keep moving along. But it sounds like there were other issues with noise in 2017.
And so you said you contacted and you didn't get much response from the board. Is that correct?
Yes.
So I have a question before we go on. You said you sent an email to Beacon Management. Is that the same thing as sending an email to the board, or is that something different? I don't know what Beacon Management is, and I don't know if they're connected to the board.
Well, I ran into a board member, and they were just telling me just report it to the
Objection, Your Honor.
So again, don't go into what other people said, just what you did. But
Right. Well, when there's an issue, we're told to contact the management company. We're not told to contact the board. We're told to contact the management company.
okay, and you did what you were told.
Right.
Got it.
And so you contacted the management company and you said that you didn't get much response. Is that correct?
Yes, that's correct.
Objection, Your Honor. Best evidence rule.
So you need to give me more than that.
Understand, Your Honor.
He's summarizing. Sorry, he's summarizing an email. The best evidence of what transpired in that email is the email itself.
Oh, okay, well, I'm going to let him summarize it. If you want to get in the email when you cross-examine him, you're free to do that.
So you didn't get much response. Did you do any follow-up with the board or with Beacon Management?
I did. I continued to follow up with emails, and nothing was really being done. And so I've also always had Deming Law as like, the legal shield. And so basically after it was probably like maybe 6 months and the complaints just kept getting worse and worse, and my tenant was upset with me. So I went ahead and had Deming Law send a letter to the board to let the board know what the issue was.
Okay, so you contacted Deming Law as a law firm that you deal with the Legal Shield, and they sent a letter on your behalf to the board or Beacon Management. Is that what you're saying?
That is correct.
Okay, and I'd like to, if I can, share my screen here. I'm looking at what is going to be referred to as Defendants Exhibit H. Can you see that screen, Mr. Rowland?
Yes, I do.
I'm sorry, not H.
Just so I can follow along, is it H or J that you're going to be going into?
Should be J. Let me apologize. I'm sorry, it's Respondents Exhibit H. I mean I.
I?
Yes, I.
Okay.
Do you recognize this document, Mr. Rowland?
Yes, I do.
And how do you recognize it?
It is the letter that I approved for the attorney from Deming and Law to send to the management company.
Okay. And this is a true and correct
Yes, it is.
representation of that document?
Yes, it is.
Now we would ask to tender Exhibit I into evidence at this time.
Mr. Tripp, any objection to Defendants I?
I only object to the extent that they are going to try to rely on statements in that letter, not entitled to an exception to the rule against hearsay, but the letter itself, I didn't object to the authenticity of it and don't now.
Okay, I'll admit Defendants I.
So this was a letter sent back in April 22nd, 2015.
Yes,
Is that
that's correct.
Okay. Stop there. And so after that letter was sent, was there any movement or repairs made to the jockey pump, as far as you know?
No.
Okay. Now, at some point, there is an indication that an email was sent regarding part of the jockey pump being moved. Do you recall sending an email to the board regarding that?
Yes, I do.
Just a moment. I'm showing now what's been labeled as Defendants Exhibit D. Does this document look familiar to you?
Yes.
How is it familiar to you?
This is the email that I sent to the Beacon Management regarding a hole that was in the wall when I came back. When I came to the unit.
And this is a true and correct copy of the email that you sent?
Yes, it is.
And this was sent to Lisa Simmons at Beacon Management Services, is that correct?
Yes.
And so can you tell us what happened with the hole in the wall?
So I came back one evening, and so I went over to talk to Danielle. And basically, when I got there, I saw the hole in the wall. I mean, it was strange. I kind of thought someone busted open the walls, and so I wasn't sure. So went into the unit, and the jockey pump was going off, and now it was vibrating the unit, and I was like, I was like, what? I was like, so I didn't know what happened, and so I went and I sent the email to Lisa asking her what was happening.
Mr. Rowland, the hole you're describing, can you give me a rough estimate of its size? Could you put your hand through it, or could you climb your whole body through it, or how big is this hole?
Yes, you could walk through it.
So it's a big hole.
Right.
Okay. And this wall that had the hole in it, was this an exterior wall to your condominium so that now you could just walk into the condominium, or what was on either side of the wall?
Oh, no. No, it was into the interior parts of the building. So the sheetrock was cut open. So the sheetrock was cut open, and it was for the internal parts of the building that's under a stairwell.
So if you walked through the hole, you're not in someone's condominium.
No,
you're
not.
in, we'll call it utility space or empty space or something.
No, sir.
Okay.
Your Honor, I would like to tender into evidence Defendants Exhibit D at this time.
Mr. Tripp, any objection to Defendant D?
No objection to the exhibit itself, but of course reserve the right to object if they use it improperly.
You've reserved that right. It's admitted.
Thank you, Your Honor. And so, Mr. Rowland, was it explained to you via this email the purpose of the hole in the wall?
Yes, it was.
Okay. And what was your understanding of what the fix was supposed to be for the hole in the wall?
So Lisa explained to me. Lisa explained to me in the email that basically they were moving the jockey pump.
Objection, Your Honor. Hearsay. They haven't laid a proper foundation for this.
Let me look at one thing. Okay. I mean, Exhibit D is in evidence, so I've read Exhibit D. Mr. Rowland, I guess you can press on. You can't talk about what Lisa said other than what's in the email already.
Correct.
Okay.
Right. So she was telling me that they were moving the jockey pump to an area, to the mechanical room.
So is the hole in the wall that you're describing, did that go into the space where the jockey pump used to be?
I don't think so. No, I don't think so.
Okay.
And so for clarification's sake, Mr. Rowland, the jockey pump is not located inside of your unit,
No, it's not.
correct? Where is it located?
Right now, the jockey pump is located in the stairwell behind my unit, but the motor of the jockey pump is now on the bottom of my bedroom floor.
Okay, so the mechanical room where the motor was going to be moved is beneath your unit, is that what you're saying?
Correct.
Okay, and prior to March 2015, that was not the case.
Right. Before that, the engine, the motor was in the stairwell behind my unit.
Okay, and was there any difference or changes to the noise made to your unit based on the movement from the motor in the hallway to the mechanical room?
Yes, there was changes to the noise.
And what were the changes?
It became about 4 times louder, and now it was actually shaking the bedroom floor.
Okay. And this is something that you actually observed yourself, is that correct?
That's correct. Yes.
Okay. At some point, did you take any pictures or video of the jockey pump?
Yes, I did.
And you did that yourself, is that right?
Yes. Yes, sir.
Give me just a moment. I apologize, man. I'm showing you what's now been marked as Exhibit E. Do you recognize this?
So I don't think there's anything for him to see. If he
Okay,
can
I'm
see it,
sorry.
okay.
Do you recognize this, Mr. Rowland?
Yes, I do. That is the stairwell next to my unit, 217.
And you said you took picture and video, is that correct?
Yes, I did.
I want to play this video for you to make sure this is a video that you actually recorded.
Well, rather than do that, I'm gonna let you ask this witness if he's familiar with it, how he's familiar with it, et cetera. Because if you play it for him, you're playing it for me. And if in the end I don't admit it, I've already watched it. So
I understand. Are you familiar with this particular video?
I'm familiar that it's one of the videos that looks like the one that I've taken to show the jockey pump.
Okay.
I mean, I've taken hundreds. I mean, well, not hundreds, but I've probably taken about 10 or 15. And so I didn't submit all of them.
I understand. Your Honor, I would ask the tender and the respondents, I'm sorry, the Defendants Exhibit E into evidence.
Mr. Tripp,
Objection, Your Honor.
all right, E is admitted and you can publish it now, Mr. Obsecki.
Thank you. So is this the jockey pump that's outside or was outside of your unit?
Yes, it is.
Okay.
So orient me, please, Mr. Rowland. I'm looking at the jockey pump now. Now I know what it looks like. Where would I go to get to your unit from what I'm looking at?
We would turn around and go back down the stairs, and it's to the left.
So this wall that the jockey pump is up against, is that a wall that is part of your unit?
No, it is not.
Is it the part of someone else's unit?
It is not.
What would be on the other side of that wall if you burst through it?
The exterior wall to Richardson Street.
Okay. And what about, it looks like the jockey pump is in a corner of sorts. What about the wall sort of to the right?
Now, the wall to the right, so below this, probably maybe 10 feet below this, that would be where my kitchen is, where my kitchen area is.
Okay. And how about what's to the right? Someone else's unit?
It's probably halfway up. So I believe my unit is like 11 feet high, and so this is like on the first rung of the stairs. So the stairs have like 2 rungs.
Okay.
This is the first rung before you go up to the next rung to the upstairs unit. You understand what I'm saying?
I do. But what you've told me is if I burst through this wall, I would not be in your unit. I would fall out onto Richardson Street.
No. Where that square thing is, I don't know if I can. Where that square thing. Yeah, the square thing is the exterior wall to Richardson Street, but the wall but see, that's the corner, right? And so to the right of that wall would be where my kitchen is.
Okay, so I guess we'll play it a little bit more and we'll see the wall that if we burst through that, we'd fall into your kitchen.
Exactly.
Okay.
I want to stop here. This video shows tags on here. It's our non-compliance by the fire marshal. So were those tags present? Well, I guess those tags were present on the video, on the jockey pump when you were taking this video. Is that correct?
Yes, they were.
Okay. And it looks as though they were stamped 2008, 2011. Now, in terms of the noise that we're hearing right now, is that typical noise that you were hearing from that unit, from the jockey pump?
That is the typical noise at that time, but yes.
Okay, we'll keep playing.
So can you pause again? We saw a door briefly up to the left. Is that the entrance to your unit?
Go back.
Well, you can't see
There, right there, that door. Is that your unit?
no, that's 317, the one upstairs.
Okay, so that's why you're saying that this jockey pump is sort of partway up the wall. It ought to be pretty darn loud for 317, just like it's loud for 217.
Yes.
Okay, got it.
Now, are you aware, Mr. Rowland, how often this jockey pump was going off?
It was very sporadic in the beginning. And gradually it became to where it was like every 45 minutes to an hour.
Okay. And do you know about when it started to be every 45 minutes to an hour?
I can't say for certain.
Okay. And do you know about how long it would do this when it was going off?
Anywhere from 30 seconds to 3 minutes.
Okay. Now, the information you provided was that you had a letter sent by your attorneys, Deming and Parker, to the beacon in 2015 regarding this noise. Is that right?
That's correct.
And the only thing that was done, presumably at the time that you're aware of, was the motor
Objection,
was
Your
moved.
Honor, improper form of question.
I apologize, and I'll rephrase. And so you all were also aware that the motor was moved from outside in the hallway to the mechanical room underneath.
Objection, Your Honor, assuming facts not in evidence.
So I didn't hear what he said.
Assumes facts not in evidence.
Okay, overruled. But let me ask you a question before we get through this. What we just saw in the video, was that, I heard about pump and motor. Was that just the pump, or was the motor also in your video?
I'm not certain. I think that was the pump. I mean, I believe that was the pump and the motor there still. Because when they told me that, I mean, can I elaborate?
You can.
When they told me that they moved the motor, I went and looked and I couldn't see the difference. I mean, because I thought they were just telling me that. I didn't really know. And so when I went there and looked, I couldn't tell the difference of what it was before or after. And so I thought they were just telling me that. And so I just kept pressing for them to fix it. I thought they were just making it up so that, I think they did something. And so I kept pressing. And so, but they just ignored me because I thought they were making it up.
Okay.
And so, just a second here. And so from your understanding, who was responsible for the repair and maintenance of the Jockey pump?
The Condo Association.
Okay. And you were provided with, as an owner, the declarations for the Condo Association, is that correct?
Yes.
I'd like to show you what's been marked as Defendants Exhibit B. Do you recognize this document?
Yes, I do.
And how do you recognize it?
It is the declaration bylaws that I received from the property management company when I first purchased the property.
Okay. So is this a true and correct representation of those declarations and bylaws?
Yes, they are.
You're not asked to admit Defendants Exhibit B into evidence at this time.
Mr. Tripp?
No objection, and I'll note that this is the same as Plaintiff's Exhibit A.
Got it. Well, we'll have it in as Defendants B.
Okay. And so as you testified that you believe this to be the Condos Association's responsibility to make repairs and maintenance, is that correct?
Yes.
Okay. And so after the letter in 2015, do you have any indication that those repairs or maintenance were made to the Jockey pump?
No.
Okay. Were you ever notified that the Jockey pump would be repaired or fixed by the Condo Association or any other management company?
No.
Okay. And so I want to direct you to now 2018, 3 years later. And were you still using Deming Parker at that time?
I was, yes.
Okay.
I am.
Just a moment. And did you have Deming Parker submit another letter to the Cityside Homeowners, the Condo Association?
We did again, yes.
I want to show you what's been marked as Defendants Exhibit J. Do you recognize this document?
Yes,
How do you recognize it?
it is. Well, let me see the word first. All right, and so it was a letter I requested my attorney to send them because I was being ignored.
Okay. And so you had the attorney send another letter, is that correct?
Yes.
And I would ask to tender Exhibit J into evidence at this time.
Any objection to Defendants J, Mr. Tripp?
Your Honor, I do not object to it coming in for proof that the letter was sent.
So I notice it's admitted. It's sent to a different management group. I appreciate we've moved forward 3 years. Maybe we'll get to 2021 soon, but at 2018, it's Access Management Group. Was there a different management group in place, Mr. Rowland?
Is that a different one? Yes. Is that a different one? Yes. Well, I mean, can I elaborate?
Objection, Your Honor. He doesn't have personal knowledge of that.
Well, I don't know if he does or not, which is why I asked. So tell me if you are aware that there was a shift in management group, or if that's news to you.
I was aware there was a shift in management groups, and so yes.
Okay. All right. Keep going, Mr. Obaseki.
Thank you, Your Honor. And so in the shift in management groups, were you communicating at that point with a different management company other than Beacon?
Yes.
Okay. And did you submit the same complaints and concerns regarding the Jockey pump?
Yes, I did.
And as far as you know, was the Jockey pump ever addressed by the second management company?
No.
Okay.
So tell me a little bit more about this, Mr. Rowland, because I just looked at Exhibit J and I may be missing it. I don't see the word pump in there at all. This seems to be a whole lot more, I don't like how things are being managed and what's the board of directors doing. It sounds like you're stirring up something a whole lot more than, hey, there's this noisy pump outside a unit that's not even mentioned in this letter. So is there a background that you think you ought to share with me about what you're doing with the homeowner, the condo association?
Well, so there are a lot of issues. And so, I kept bringing up the different issues that were occurring. And again, I was being ignored. And so my attorney they recommended to send a letter so that the board would have a, I guess, concrete idea of what the issues were. And so it was just constant. So it's constant it was constant ignoring me, and I'm not sure why. It just seems like they were just ignoring me. And so the only way I could get a response was by sending letters. And so
why were you interested in the membership list of all eligible mortgage holders?
Oh, so every year there's an election for board of directors. And so I at least wanted to attempt to be able to run for the board to see if I can assist in resolving some of the issues. And so the way by doing that is you have to have the eligible voting members to vote for you to be on the board.
Okay.
And so, Mr. Rowland, other than the Jockey pump, did you have any other issues with your condo unit in terms of things that were the responsibility of the condo association?
Yes, and so the result of water damage. Can I mention other things other than what's mentioned in the letters that I have?
So you should start answering the question, and if there's an objection, Mr. Tripp knows how to do that, and he'll object.
Okay, so so there was a lack of painting of the building. There was a lack of
Objection,
repair.
Your Honor. To the extent that this is getting outside of what my client was given fair notice of in the counterclaim. I'm going to object to any other issues not raised by the pleadings. The jockey pump and the alleged water damage are the only issues fairly raised by the counterclaim.
Mr. Obaseki, your thoughts on that?
I would like to focus on what we've submitted, Your Honor. So Mr. Rowland mentioned water damage. Let's address that.
Okay, so Mr. Rowland, we're going to stay on point. Jockey pump, water damage. That's it.
Sounds good. So there's water damage as a result of water coming in from the roof to my unit.
So how if you're unit 217 and you showed me 317, looks like 317 is on top of 217. How do you have a roof?
Well, I mean, the ceiling, did I say roof? The ceiling of my unit.
Okay.
Okay. And so you're saying that the ceiling of your unit had water damage leaking from the roof?
Yes.
Okay. And did you ever have any occasion to take any pictures of any water damage that you had to your unit?
Yes.
Showing you what's been identified as Defendants Exhibit G.
Before you scroll down, please scroll back up before we got to lay the foundation first.
Do you recognize?
You should have a copy of Exhibit G.
Yes.
So if you've got that in front of you, Mr. Rowland, that's a much smoother way to do it, what Mr. Tripp is suggesting. If you've got Exhibit G in front of you, take a look at it. It may not be called Exhibit G, I don't know, but Mr. Obaseki needs to get Exhibit G to you so you can see it without all the rest of us seeing it, so he can ask these initial questions.
Okay. I can pull up on my phone.
Let me know when you have it, Mr. Rowland.
Yes, sir. Exhibit G. I have it I'm sorry, and the question I need to answer is
You recognize Exhibit G as
yes.
pictures that how do you recognize them?
I took these photos when the water damages were occurring.
Okay. And are those pictures a true and correct copy of the pictures that you recall taking?
Yes.
And I would ask to tender Exhibit G into evidence at this time.
Mr. Tripp?
Objection, Your Honor. We don't know when the photographs were taken.
So would you like to ask Mr. Rowland any questions about that?
Yes, Your Honor. When were these photographs taken, Mr. Rowland?
It was, you need the date? I can look and see when the date is, but it was approximately in September. There was a storm called Irma.
Okay.
Did you say September or December?
September.
September of what year?
I want to say 2017. I think
Okay. And so these pictures were taken after a bad storm. Is that correct?
correct. During the storm.
During the storm. Okay.
Yeah, like when these pictures are being taken, the storm is actually going on at that time.
Okay. And the storm caused water damage to your unit. Is that what you're testifying to?
Right.
Okay. And Was there any resulting damages that you had to pay as a result of the water damage?
Yes, I had to repaint the area of the ceiling. And basically what the claim adjuster was telling me was that there's more
Objection,
damage.
Your Honor, hearsay.
Yeah, let's not go into what the claim adjuster told you.
Right, so the question was there any damages?
Yes.
And if so, what were the damages?
So that area of the ceiling, I'm gonna say approximately about 15 to 20 feet of the ceiling was buckled down because of the water that was sitting in the roof. And so I had to get a screwdriver and poke a hole in the ceiling so the water would drain out.
Was there damages to the floors or any other areas of your unit?
Right. So there was damages to the floor in the area right in front of the Juliet style door.
Okay. And you mentioned a claim adjuster. Does that mean that you filed an insurance claim?
Yes, I did.
Was that insurance claim paid?
It was partially paid.
Okay. You say partially paid. Why was it partially paid?
Because all of the damage wasn't identified.
Okay. So there's basically more damage than what was paid by the insurance company. Is that what you're saying?
Correct. That's to my understanding that there is potentially more damage there in the roof area.
And I assume you had to pay a deductible for that insurance claim?
Objection, Your Honor, and proper form of questioning.
I'll rephrase, Your Honor. Did you have to pay a deductible for that insurance claim?
Yes.
How much was the deductible?
I believe it was 500.
Okay. Now, have you received any notification from the condo association regarding the roof or repairs that need to be made?
Right. We received notification from the condo association that the entire roof of the building needs to be repaired. Due to the amount of repairs that need to be redone, they explained that it would be done in sections. And so one section was done last August, if I'm not mistaken, and there was a special assessment to do a section in this August, but there have been no further roof repairs done.
And did the condo association send emails explaining that?
Yes.
Okay. I want to have you look at what's marked as Defendants Exhibit H, Mr. Rowland. Can you look at that? I think you have it on your phone.
Okay. Yes. Yes, that is one of the emails that was sent out by the condo association.
And you recognize it as a true and correct copy of the emails that you were sent by the condo association?
Yes.
And I would like to tender Defendants Exhibit H into evidence at this time.
Any objection to Defendants H, Mr. Tripp?
Yes, Your Honor, they haven't laid the proper foundation under OCGA section 24-8-801D. There's statements in here, they haven't laid the proper foundation to get those in under an exception to the general rule against hearsay.
Your Honor, I would say that he's testified that this was the condo association's email blast to all residents, that he received it and that he recognizes it as the condo association's email to him and other residents regarding the repairs.
Your Honor, we haven't heard who this individual emailing is or what relationship she has to the plaintiff.
Your Honor,
Okay.
Okay.
I'm going to allow it in and we will proceed.
Thank you, Your Honor. And so, Mr. Rowland, you testified, I believe, that the phases are ongoing, but your unit has not been repaired yet. Is that correct?
That's correct.
Okay. Just a moment. Now, I want to get to more recently. You testified previously that you had a tenant in the unit up until, I think you said the end of 2020.
That's correct.
Is that correct? And you no longer have a tenant in that unit. Is that correct?
That's correct.
Why not?
The sound from the jockey pump was too much. I mean, at the time, it was so, how can you say? It was happening so often that, I mean, if you go there, you hear it. I mean, it was happening on a regular basis.
Okay. And the, have you made any efforts to get the unit rented?
Yes.
When was it that the tenant moved out?
In December of 2020.
December of last year?
Correct.
And what was your tenant paying in rent?
She was paying, well, it was 900, but I was allowing her to pay a little less, 825. So.
Why is that?
Well, we have issues with, I mean, it was issues, and I mean, I need to keep someone there, so I allow her to pay a little less and when she can.
Okay. So for how long was she paying the, I think you said 825?
From about, can I elaborate a little bit? Well, I'm saying from about, let me see, 2000, maybe 2016, because I was increasing the rent by $50 every 6 months. And so, the issue was there, so I couldn't do that. So after that first year, when I increased it the first time, from 2014 to 15, I didn't increase it again because of the issue with, the issues that were being done.
Okay. And so since December 2020, you haven't had a tenant in that unit. Have you made any efforts to get a tenant in that unit?
Yes, I have.
What efforts have you made?
I have brought about 4 people there to rent the unit. I've used stuff like Nextdoor and working through real estate agent to get people to attempt to rent the unit. But when I brought them to the unit, jockey pump is outside, and so they heard the jockey pump. And then when we went into the unit, the sound of the jockey pump is in the unit, and like they step 3 feet into the door and shake their head like, no, thanks.
Okay. So I think you said you had 4 people that you showed the unit to?
About 4, yes.
And they all declined to rent it because of, from your understanding, because of the jockey pump? No.
Yes.
And have you ever attempted to stay in that unit?
Yes, I have.
When was that?
I attempted to stay there in around February of this past year, 2021.
Why was that?
Because I couldn't rent it out. And so I figured that I would just live there and endure it and just rent my unit, 209, out.
So you have another unit in the complex?
Yes.
You said 209?
209, that's correct.
Okay. And that's where you reside, in 209?
That is where I am right now.
Okay. So what happened when you tried to stay in the 217 unit?
I couldn't sleep, and the headaches were ridiculous. I mean, it was kind of like torture. So imagine, so again, the bedroom floor vibrates. And so if you're on a bed, your bed is vibrating. And so you immediately wake up, or you can't go to sleep if it starts. And I mean, it's just unbearable.
And when you were there, how long, how often was the jockey pump going off?
It was going off, like it's probably about every 45 minutes to an hour. Because I didn't realize it got that bad. But yeah, about every 45 minutes to an hour.
I want to jump back for a second to the roof damage that you testified to earlier. You noted that you had taken some pictures of the damage back in, I think you said 2019. Is that right?
He said 2017. He linked it to Hurricane Irma.
I'm sorry. I apologize. Give me just a second. And you said you'd taken pictures after Hurricane Irma and sometime around 2017. And what were the pictures of exactly?
Those pictures that I've shown are pictures of that's the living room area next to the Juliet style door that goes out into that faces the courtyard. And so those pictures of that area in front of the Juliet style door, probably half of the ceiling and the floor in the area where the water was coming under the door and from, I mean, it was coming from the wall, inside the walls. I mean, I thought I had a video, but the water was coming from the walls, like coming out of the wall, like the wall that's next to the door.
Defense would like to tender Defendants Exhibit G into evidence at this time.
Mr. Tripp?
Objection, Your Honor. There are a lot of days in September of 2017. If he can't tell us when this picture was taken, there can be no proper foundation because he can't testify to the fact that the picture is reflective of the condition of the living space at the time that the picture was taken.
I'm not sure I fully understand Mr. Tripp's.
That's okay. You don't need to. I'm not aware of that being the way foundation is required to be laid. I'll admit it for what it is, which is testimony is that it's photographs taken at some point in September 2017. If it becomes material that, hey, it has to have been September 12th, that's not what Mr. Rowland has said, but he has testified that this is what his ceiling looked like in 2017, September 2017. I find that to be a sufficient basis to admit them for photos of what the ceiling looked like at some point in that month. So G is admitted.
I just want to. Are these the pictures that you're referring to, Mr. Rowland?
Right. Like, you see how that is? Like, that water there, that is coming from inside the walls. And this is what was explained to me about there's other.
So don't go into what was explained to you. Just talk about the pictures.
Right. And so, right. And so
What
this
is
is
that we're looking at.
So this is the Juliet style door that faces the courtyard. And so in this picture, what's happening is, like, you see the drips and stuff. So water is coming out. The water is coming through the walls, through the framing of the door.
Okay. And what are we looking at here?
So this is where water was building up in the ceiling and it's buckling down the ceiling. And so I believe this is like one of the scenes where the sheetrock, is joining two different drywall boards or something like that.
I understand. And what are we looking at here?
So that's the floor. The floor in front of the Juliet style doors where water is coming through the it's coming down. So it's coming down the wall and it's rolling into the floor, believe it or not.
Okay. Thank you. Now, obviously, we've talked about different management companies, Beacon, there was another one. And have you had any conversations or communications with the current management company regarding the jockey pump or the roof?
I had not had any conversations with the current company regarding these. It's
Okay. I have no further questions right now, Your Honor. I reserve the right to follow up with Mr. Rowland.
All right, Mr. Tripp, do you have questions for Mr. Rowland?
Mr. Rowland, what do you do for a living?
I have a landscaping company right now.
You don't work on fire pumps for a living then, do you?
No, I do not.
Did you go to school to learn about fire pumps?
I did not.
You don't work for a government agency charged with inspecting fire pumps then, do you?
No,
And you don't know how many decibels the fire pump emits when it's functioning, do you?
at this point, no.
And you don't know how many decibels a typical or properly functioning fire pump emits then, do you?
No.
And you were able to rent unit 217 for over 6 years, were you not?
Approximately, yes.
Can we just call it 6 years then?
Yes.
Okay. That concludes my cross-examination of this witness, Your Honor.
Mr. Obaseki, any redirect?
Just briefly, Your Honor. Mr. Rowland, you did take pictures of the jockey pump outside in the hallway, is that correct?
Yes.
Okay. I want you to look at what is labeled as Defendants Exhibit. Defendants Exhibit F. I believe you should have it on your phone.
Okay. Yes.
Do you recognize those pictures?
Yes, I do.
How do you recognize them?
These are the inspection tags that are on the jockey pump of the non-compliance.
These are tags that you took pictures of that were actually on the pump. Is that correct?
Yes, that's correct.
And you could kind of see them from the video earlier. You know, I'd ask the tender into evidence, Defendants Exhibit F.
Mr. Tripp?
Objection, Your Honor. It's cumulative to the extent it's just a screenshot of the video that's already in evidence. And I also object to any use of the tags for the truth of the matter asserted, because there's been no proper foundation to get the tag or what it says in.
Okay. I'm going to allow them in. They are cumulative because we've got that on the video, but they're being admitted for now solely as photos of things that were stuck to the jockey pump and not for the truth of the contents of either of those tags.
And so, Mr. Rowland, you didn't place these tags on the jockey pump, is that right?
No, I did not.
You simply took pictures of the jockey pump and these tags were already on them. Is that correct?
Yes.
Okay. Just a moment. but the tags read non-compliant tag. Is that correct?
So don't get into the contents of the I mean, the photo's in, I can read it, but I don't need Mr. Rowland talking about what's in there or insinuating why it might say that or anything like that. Not his role.
I understand. And so, is there anything else that you would like for the court to know that we haven't addressed, Mr. Rowland?
So regarding the pump, I guess regarding the pumping, the water damage, I mean, it's just a horrible ongoing issue. I mean, I just need it to be resolved to be able to live in the unit so that.
Mr. Rowland, do you still own 209? I guess so. You're in it right now. And 217 is empty. You've tried to lease it. Have you tried to sell 217?
I have not tried to sell 217 recently.
Since your tenant moved out in December of last year, have you tried to sell 217?
I have not attempted to. Well, there's a lien on the property. The lien started before she moved out, so I have not attempted to sell the unit.
Okay. All right. May Mr. Rowland effectively virtually step down from the stand, Mr. Obaseki?
Just one follow-up question, Your Honor. The email that we referred to earlier, Mr. Rowland, regarding the roof repairs, that was an email sent to you, is that correct?
Which exhibit is it?
This is Exhibit H.
It was not sent just to me, no.
But it was sent to you.
It was sent to me, but not just to me. Yes, that's correct.
Okay. And that email appears to be from Beacon Management Services. Is that correct?
Yes.
And Beacon Management Services was the management company that you testified earlier was the management company for the Condo Association. Is that correct?
Yes.
Okay. Your Honor, we would like to tender Exhibit H into evidence. Mr. Rowland.
H is already in. Mr. Tripp objected. I overruled his objection.
Oh, okay. Thank you. We have no further questions, Your Honor.
All right. So, Mr. Rowland, thank you. You can go back on mute. Mr. Obaseki, any other witnesses?
I am checking as we speak. Your Honor, I do have one other witness, but I need a brief recess to call her to get her on the line.
All right. There's a Rebecca's iPad that's on the call. That was someone who joined since we began. I don't know if that's who you're looking for.
I'm not sure. Is Ms. Vanessa Moreau on the line?
Your Honor, before we go too far down this road, I'd like to come back to my earlier objection and renew it. Under this court's standing civil trial order and from direction of your staff attorney, we were told that we had to submit an exhibit and a witness list 2 days before today's trial. So we did that. And then yesterday evening, less than 24 hours before today's hearing, my colleague tried to amend his witness list to add a new witness that was not previously disclosed on that initial witness list that just listed Mr. Rowland and Simon.
Okay, right. I see. I'm looking at the initial witness list, and now I've got an amended witness list, and it adds, all right, Ms. Moreau. So tell me, Mr. Obaseki, why there was the late addition of a witness?
It was twofold, Your Honor. One, the original witness, Simon, is the unit owner of 317. That was the condo unit that you saw in the video that was above. He does not live there. He's just the owner of the unit. He did have multiple communications with the condo association about the complaints, but all of his testimony would be from his tenant, Vanessa Moreau. For whatever reason, or not for whatever reason, it's my understanding from Simon that he also has pending issue or litigation with the condo association and didn't initially want to give me his tenant's name. For whatever reason, he eventually did, as well as her contact information. I was finally able to reach her yesterday. I wasn't able to speak to her prior to that. She actually is, I think I noted to the court before, not in town. She's in California or on the West Coast somewhere. But that was the first time I was able to actually identify that witness. As I put into the email, her testimony essentially is just firsthand testimony as opposed to what would have been hearsay testimony from the witness that's actually currently on the original list.
When did Mr. Kasai give you Ms. Moreau's contact information?
That was exactly when. It was not prior to the deadline of the 2 days. I would also note that the document that Mr. Tripp is referencing doesn't speak specifically to witnesses, but instead to evidence.
Well, witnesses provide evidence. Tell me, Mr. Tripp, what the prejudice is to your ability to meaningfully cross-examine Ms. Moreau. If you had gotten her name 36 hours earlier, it would have been timely. So one, I could just grant a continuance and we could pick back up. What is it that you would want to do between now and then so that you'd be in a different position than if, assuming we get Ms. Moreau, this may be moot because I don't see her. But tell me what you'd be doing.
Well, Your Honor, the 6-month discovery period is over. So I would not be able to, absent an extension or reopening of discovery by the court, be able to depose her, at least involuntarily. So the prejudice is more just 11th hour surprise. But if the court's inclined to either let her testify or grant a continuance, the plaintiff would choose to permit the testimony given that choice.
Okay. Yeah, no, I'm inclined to give you the choice, Mr. Tripp. I think that you're entitled to reach out to Ms. Moreau, try to talk to her, see if she'll talk to you, as if you had 48 or more hours to get ready for that. I hear you that you couldn't compel her to sit for a deposition. I don't know that that would be in your client's financial best interest to spend that money either way. But if your preference is let's press on, I'll do that. I just want to make extra clear that if your preference is instead, we're stopping and we'll start back up again when we can get time on my calendar. But you want time to try to contact Ms. Moreau, I would give you that opportunity.
We'll press on, Your Honor.
Okay. So, Mr. Obaseki, now is the time to have Ms. Moreau talking to us.
Yes, Your Honor. I'm sorry. I'm trying to reach her. Your Honor, can I take a brief moment to call her?
Yeah, you can. I don't know. I mean, it seems like you got Mr. Williams on this. You got the whole law firm. I've got 3 different lawyers' names on some of the pleadings that you all filed. So I'm wondering if the firm could pitch in and you could But if you want to take 5 minutes, I wouldn't give you 5. If you want to take 2 minutes, you can do that. Otherwise, we need to keep moving on.
2 minutes will be sufficient, Your Honor.
All right, it's 3:56. We'll see what happens at 3:58. I'll be right back. Hey, it's like, he's hiding. How are you? Good. Good to see you.
Jeanette.
All right, got a bonus minute. It's 3:59. How are we doing, Mr. Obaseki? No luck with the West Coast?
Yeah, she should be logging in now. If
Should
you
be
see any
logging
log
in.
in.
Your Honor, I'm sorry, I was just notified that she's asking for 15 minutes before she can log in. Apparently, she didn't have access to reliable internet or computer, but she's going to a place now to get back.
So we don't have 15 minutes. This started at 2:30. I appreciate the West Coast is a different time zone, but it's 3 hours. It's not 18-hour time difference. Do you have other witnesses you want to call?
We don't have any other witness, Your Honor.
Okay. So Mr. Tripp, my thought would be if you want to start your presentation, we'll get one of you. I don't know if you had any witnesses. I don't mean to presume you have any at all, but there were these folks who are on the call. We could start with them. And then if Ms. Moreau shows up, we can pause, get her testimony in. I trust Mr. Obaseki will be surgical in his precision in questioning her, since of course she doesn't live in 217, she lives in 317. And then we could get back to your presentation. Does that work for you? I don't want to sit around for 15 minutes.
I don't either, Your Honor. One issue is I'd like to make a motion for judgment as a matter of law or directed verdict. Here, there's no jury to direct.
Okay.
But I'm not going to do that, obviously, until the case in chief closes, or rests. So I would really almost prefer that we wait, because I would like for them to rest and then we present our rebuttal case.
Well, I'm torn then, because I am not feeling in any way confident that Ms. Moreau will join us in 15 minutes. Not that she won't join us. I just got a sneaking suspicion we'll be sitting around for more than 15. And that's not fair use of anyone's time. Ms. Niles asked how long this presentation would take, and looks like we're going to bust through that 5 p.m. limit. And so I'm wondering if what we ought to do, consistent with preserving Mr. Tripp's right to make his argument only after plaintiff has rested, and not maybe pointing out issues that he thinks I say plaintiff, it's really defendant. Flip the roles here. And let me do this. Much better. Okay. I'm wondering if it makes more sense to say we're just going to stop now and we pick a date and time when we reconvene, at which time Ms. Moreau is here or she's not. It's not wait 2 minutes, it's not wait 15 minutes, or we're actually 92 minutes into this proceeding and Ms. Moreau is not here. So that's where we are. I know, Mr. Tripp, you were not real interested in a continuance, but if the way we're going to handle it now is I'm not going to make you give your motion for judgment as a matter of law until Mr. Obaseki says I'm resting, where do you want to go with that? I understand your initial vote would be, well, you know what? It's not plaintiff's problem that Ms. Moreau, who was late noticed, is now late to the trial. But beyond that valid point, what's your preference?
Given those two choices, we will move forward, and I suppose that I will reserve my argument until such time as Ms. Moreau appears or doesn't appear. So
why don't we do this? You certainly preserve it and reserve it. We're doing this a little unorthodoxly, but we're also doing it virtually. So a lot of things are different. Let's get started. And if by 4:15 on my clock, we don't have a Ms. Moreau, we're not going to have a Ms. Moreau, and we'll pause then. You can stop your direct examination of whoever your first witness is. And I'll ask Mr. Obaseki if he's got any other witnesses. If he does not, he will have rested, and you can pivot from your direct exam to your argument. Okay, that way we're at least using everyone's next 12 minutes, actually 10 minutes. Okay.
Okay, so I'm going to call first Mr. Jeremy Powell.
All right, Mr. Powell, thank you for your patience.
And Your Honor, would you like for me to swear him in, or is the...
No, we've got a deputy. We just have a different deputy, just as good as the previous one, but he's going to come on up and let me put Mr. Powell in the spotlight. There he is. Deputy's going to come. If you come up to that screen there, he can see you, and you'll see him. You'll make sure he's raised his right hand.
You raise your right hand. Do you swear in or affirm that the testimony you shall give to the court is the truth, the whole truth, and none but the truth?
I do.
For the record, can you please state and spell your first and last name?
Jeremy Powell, Jeremy Powell.
You can put your hand down now, sir. Thank you.
Okay, so Mr. Powell, what is your affiliation with the plaintiff, Cityside Lofts Condominium Association Incorporated?
I'm part of the board of directors and I'm acting president.
Does that mean you live in one of the units at Cityside?
Yes, Your Honor.
Your Honor, the party's contract, the declaration is already in evidence. So I'm going to go ahead and screen share. And unless anyone objects, it's already in evidence. So we're going to go ahead and use it without wasting the court's time.
Great. No, it is. It is defendants. Where did it go? B, defendant B. I know you called it A, but it's the same document. So
Same exact document.
yep.
Mr. Powell, have you read this document before?
I'm familiar with it, yes.
And do you have to be familiar with it to serve as a director and officer of the not-for-profit corporation?
Yes, I do.
Under the declaration, does the association have a maintenance obligation?
Yes, we do, under Article 17.
Tell me more about that.
Well, we have to keep the area of common responsibility in good repairs. Also, if we're doing like a maintenance job and we happen to incur damage to a unit, then we're also responsible for that.
Tell me more about the area of common responsibility. What is that?
That is the common elements and any area that is deemed responsible for the association.
And what are the common elements of the condominium?
The common elements are the portions of the condo that are without the bounds of the actual unit. They're outside the bounds of the actual individual units.
It's like a stairwell, or I assume the roof, because everyone shares the roof.
Yes.
Okay.
And how does the association pay for keeping the area of common responsibility in good repair?
It's a common expense. We assess it to the owners.
Does Cityside Lofts have a fire pump?
Yes.
What does it do?
It's a critical element to our sprinkler system. It helps protect the building and the residents from fire.
Did the association ever receive any complaints concerning this fire pump?
Yes.
Mr.
And what
Powell, how long have you, I'm sorry to interrupt. I just want to get a little more context. How long have you been on the board?
Since February of this year.
And so presumably you were not president before then.
No, Your Honor.
Okay.
And what was the issue with the fire pump?
We received complaints that it was too loud.
And what did the association do in response to these complaints?
We sent out a specialist to examine it.
Now, following this inspection, did the board of directors repair or replace the fire pump?
No,
Why not?
we were told it was in working condition. Good working
Yeah.
condition.
Now, turning to the defendant's alleged water damage, did the defendant ever notify the association of any defect or need for repairs?
No,
And was he required to do so under the party's contract?
yes. Again, under Article 17, we have to be notified. If we're not notified, in a gist, we have to be notified. If we're not notified, we're not liable. And if we are notified, we have to be given at least a reasonable amount of time to address the issue. So
I'm going to ask you to read the first sentence of this paragraph here.
The association shall not be liable for injury or damage to person or property caused by the elements or by the owner of any unit or any other person or resulting from any utility, rain, snow, or ice, which may leak or flow from any portion of the common elements or from any pipe, drain, conduit, appliance, or equipment which the association is responsible to maintain hereunder, except for the injuries or damages arising after the owner of a unit has put the association on notice of a specific leak or flow from any portion of the common elements, and the association has failed to exercise due care to correct the leak or flow within a reasonable time thereafter.
Okay. And how do you know that the defendant didn't notify the plaintiff of his alleged leak or flow?
We keep records in communication with the property manager. And I, for one, did an extensive search and I could not find any issues pertaining to the defendant's complaints. And that is something that we keep on file. So I was unable to find that.
And you found evidence of the defendant notifying the association of a noise complaint,
Yes,
but not an alleged leak or flow resulting in water damage to his unit.
that's correct.
So let me make, I think I understand this, but let me throw a fact pattern at you, Mr. Powell. I'm in unit 111 and a storm hits and all sorts of water comes in and messes up my unit. I write you all a letter. If there's a second leak and it's because you, not you personally, but the COA didn't get the roof fixed, the COA is liable for the damages caused by that second leak. But that first one, that's on me and my insurance because the COA didn't know that there was a problem. Is that a fair summary of how that paragraph you read works?
Correct.
And what was the paragraph, Mr. Tripp? It's B, is it 17? I see the paragraph, but what is it?
It's section B of Article 17 of the Declaration.
Got it.
Or you could call it section 17B.
Yep.
If you wanted to phrase it that way.
Yep. Okay.
Okay. Is there anything in the declaration that obligates homeowners to notify the association before they file a lawsuit against it?
Yes, that is also, well, that's actually Article 19.
Okay, can you tell me more about that?
Any owner, if they decide to file a lawsuit against the board, they have to have a hearing first, and that has to be submitted in writing, and that has to be on file.
Right. Can you read this paragraph here of the parties' contract?
Sure.
Is this 19B?
This is section B of Article 19 of the Declaration. Yes, Your Honor.
So prior to filing a lawsuit against the association, the board, or any officer, director, or property manager of the association, a unit owner or occupant must request and attend a hearing with the board of directors. Any such request shall be in writing and shall be personally delivered to any member of the board of directors or the property manager. If any of the association, the owner or the occupant shall, in such request and at the hearing, make a good faith effort to explain the grievance to the board and resolve the dispute in an amicable fashion, and shall give the board a reasonable opportunity to address the owner's or occupant's grievance before filing suit. Upon receiving a request for a hearing, the board shall give notice of the date, time, and place of the hearing to the person requesting the hearing. The board shall schedule this hearing for a date not less than 7 or more than 21 days from the date of receipt of the request.
And when you searched the board of directors records, did you find any demand for such a hearing from the defendant?
No.
That concludes my examination of this witness, Your Honor.
All right. If you would stop sharing your screen, please. I'll be able to see a couple things a little bit better.
Okay. Let me- Here we go. Stop share. Sorry.
Excellent. No problem. All right. So we're at 416. I don't see, but I'll let you inquire, Mr. Obaseki, whether our friend Ms. Morrow has joined us.
She has not, Your Honor.
Okay. Do you have any questions for Mr. Powell? Or should we turn to, I don't want to leave him hanging. He can go if you ask your questions. I'm going to view your evidence as closed, but I'm going to hold off on a minute to have Mr. Tripp make the argument he wants to make so we can close out on Mr. Powell. Do you have any questions for him?
Yes, Your Honor, I'll be asking the questions.
Oh, all right, Mr. Williams, have at it.
Mr. Powell, is it correct that you said that you just joined the board in February of this year, correct?
Correct.
So you have no firsthand knowledge of any interactions as a board member with the owner of Unit 217, correct?
Correct.
You're also, you are, am I correct to assume that you're not a lawyer, correct?
I'm not a lawyer.
So those provisions that you read from the covenants that talk about liability and duties and requirements, you were just reading that as to the words that they actually say, correct? Not providing any kind of analysis on that, correct?
Yes, I'm reading it from the declaration, yes.
Now, you read in the declaration about an owner's responsibility to take certain actions before filing a lawsuit against the association, correct?
Yes.
That's what you read? Now, I know you were not on the board, but are you aware that this lawsuit was actually initiated by the association?
I'm not aware.
Okay, so would it surprise you to know that the association initiated the lawsuit that we're involved in today?
Oh, I'm sorry. You talking about this is a counterclaim to our original claim. Is that what you were saying? I'm sorry.
Correct. The action was initiated by the association. Is that correct?
Oh, yes.
The section that you read from the covenant, did it speak to actions initiated by the association?
Objection, Your Honor, calls for legal analysis.
Well, I think that Mr. Williams has established that Mr. Powell's not going to offer any analysis. No, he used the phrase speaks to, but I'm taking that to mean, is there any reference to or mention in 19B about counterclaims?
That is my assertion. Your Honor. So if I may, sir, does that 19B section under your reading say anything about counterclaims?
Objection, Your Honor, calls for legal analysis. The court's going to apply the law to the facts. He can only speak to what the declaration says.
I hear you. And what I hearing Mr. Williams asking Mr. Powell is, does it mention counterclaims in 19B? It's not on my screen anymore, so I don't know if it does. We may need to put it up for Mr. Powell. Not a trick question. Either it talks about counterclaims in there literally, or it doesn't. It may be that the concept of counterclaims is covered by the language. That's legal analysis, and that's not what I'm hearing Mr. Williams asking Mr. Powell to engage in.
I don't have the document in front of me.
Well, if we can get it pulled back up. Mr. Obaseki, could you share your screen with that covenant section 19B, please?
Yes.
While he's sharing that, just for the interest of the court's time, let me go into another question. I'll come back to that once it's shared.
Thank you.
Objection, Your Honor. I'd like to finish the question before we move on.
Well,
Well,
I'm keeping the question open. We'll get back to it. You can move to a different area, but we won't leave it hanging.
We will not leave it hanging, I assure you, Your Honor. Mr. Powell, you've been sitting through this entire hearing, correct? So
Correct.
you've heard the testimony of Mr. Rowland, correct?
Yes.
You also got to see some correspondences that were emails and attorney letters sent to the association and comments from the association, correct?
Yes.
Mr. Obaseki, I don't know if you're showing what we've asked for. If you can unshare your screen and then share it back when you have the document.
All right.
In the interest of keeping it moving along, I
Just
can
unshare your
share my
screen for
screen.
a second. All right. So you've seen about correspondence to and from Mr. Rowland and the HOA, correct?
I saw between the property management company, yes.
Correct. And you testified that it is through the property management company that owners are to communicate concerns. Is that correct?
Correct.
So when you testified earlier that you found no communications of any issues from Mr. Rowland to the HOA, were you eliminating the documents that we saw, or was this your first time seeing those documents?
These were the first time I saw those documents.
Okay.
But
So
Wait, let him finish his answer. You were saying something more, Mr. Powell?
but through the communications that I have with my current property management company, what I've searched there, I did not find anything in relation to the defendant.
So you would agree, though, that the association has had several property managers over the period of time that we're discussing today, from 2012 through 2021. Would you agree with that?
Yes.
Also, during Mr. Rowland's testimony, do you remember him testifying that he had not had any communications with your current property manager?
Yes.
So would it surprise you then that your current property manager does not have communications from Mr. Rowland?
No.
Now, here's the document that we were just talking about. Do you see it on your screen?
Yes.
And we were referring to the section called dispute resolution, which is the very top, section B. We're on the same page here?
Yes.
In a review of that section, do you see anything that states the word counterclaims in that section?
No, sir.
And the beginning of that section, can you just read that very first, after dispute resolution, before the first comma? Can you read that section right there?
Prior to filing a lawsuit against the association.
Okay, so again, you are aware that this lawsuit began with the association filing an action against
Objection, Your Honor, asked and answered.
the owner of.
So,
Unit.
Mr. Williams, there's an objection that you're
I'm
going
sorry, I
into.
couldn't-
That's
I
okay.
apologize.
That's okay. Zoom doesn't work real well when folks talk over each other. Mr. Tripp has objected that this is asked and answered. You may have had more to your question, but the start of your question was getting Mr. Powell to say again, which he has, hey, it's the association that started this particular lawsuit.
And I apologize, Mr. Tripp, I did not hear you, I apologize.
That's fine.
I will move on. Mr. Powell, you're the president of the association. Did I understand that correct?
Yes, sir.
So are you aware that the roof in the building that Unit 217 is housed in is in need of repair?
Objection, Your Honor, assumes facts not in evidence.
I'm sorry?
He's
Overruled.
asking,
I
I'm sorry.
heard the question. Overruled.
Mr. Powell, can you answer my question, please?
I'm sorry, repeat the question.
Are you aware if whether or not the roof where Unit 217 is housed under, that building, if that roof is in need of repair?
objection, Your Honor, irrelevant. This is an individual board member who cannot speak to the board's determination whether or not a common element needs to be repaired or not.
Do I need to
Overruled.
respond?
You can answer the question, Mr. Powell.
To my knowledge, we have to keep everything in good repair. So I do know that we have to eventually take care of the roofing situations.
So there was a email that was presented to evidence earlier that dealt with roof repairs. Do you remember seeing that on the screen while you've been watching?
I actually don't know if that was ever shared on the screen.
I don't remember seeing anything about that.
Yeah.
Okay. Do you
And
remember?
you're not required to have memorized everything that popped up on the screen. So it's okay to say, I don't remember it.
Right. Do you recall that conversation? If not, I can bring it back for you.
About the roof?
Yes, about roof repairs in the association.
Yes.
Okay. You're the president currently. Have you allocated funds or prepared a budget that would include repairing the roofs of the units within the association?
Yes.
So is it fair to say that you would not be repairing the roof if it did not need repairing? Is that a fair statement?
If the roof does not need to be repaired, we would not repair it, no.
Right. But you have allocated funds to repair the roof in your budget, correct?
Yes.
Okay. So I'm going to assume then that for a moment that, well, I don't want to assume. Let me back up. I apologize. The roof, and I don't know the names of the building. What is the number of the building that Unit 217 resides in? Do they have letters or numbers?
Not really, but it's on the Richardson Street side. So we would call that maybe the third building.
When is that roof going to be scheduled to be repaired?
Next year.
Next year. So currently that roof is in need of repair. I just want to make sure that we can get past, I'm not sure why we're doing these semantics, but are we on the same page that that roof is in need of repair?
I'm not aware of how much repair, but
I
I do
didn't ask
know.
that.
You know what? I think you made your point, Mr. Williams. Mr. Powell has said, we would not spend money on it if we didn't need to. And they plan to
Okay.
spend money to work on the roof of the third building. So it must need some amount of love and affection.
Okay, so Mr. Powell, just to move us along, the pictures that showed water on the ceiling of Unit 217 that was coming, according to Mr. Rowland's testimony, coming from inside of the wall. You remember, do you by any chance remember that testimony?
Yes, I do.
Have you found any correspondence from Mr. Rowland, or have you become aware in your preparation for this case or anything of Mr. Rowland complaining about that issue when he filed his insurance claim? Have you become aware of any of those circumstances?
No.
Okay. I got one last thing I want to make sure. We talked about the, I think Mr. Tripp had asked you, and if he didn't, I apologize, but I thought I heard him ask you about repairs to the jockey pump. Do you recall that?
Yes.
And was it your testimony that you are unaware of any repairs being made to the jockey pump?
I'm sorry. No, we were told that it was working functionally. It was in good stance. So we did not assign any repairs or anything.
Were you told that during your 2021 term, or is that from records that you've seen from the past?
2021 term.
So when did you, who advised you that the jockey pump did not need any repairs?
We were told from our property manager at the time, from a reliable source, well, our expert in Alliance sprinkler fire system.
So you met with someone from, what is the company called? Alliance?
Alliance.
They met with you, or they provided your report?
They provided us a report.
And when did they provide you that report?
I don't know the exact date. I would say sometime during the summer.
During the summer of 2021?
Yes.
Now, those tags that you saw photos of and that appear on the video from the fire department, do those tags currently reside on the jockey pump, to your knowledge?
I don't know for sure. No, I don't know.
When was the last time you visited the jockey pump area as the president?
I would say 2 months ago.
So 2 months ago, when you visited, did you see those tags on the jockey pump?
I saw tags. I didn't actually look directly and see if it was the exact same tags, but I did see tags.
Now, are you aware, as the president, what the purpose of those tags are for?
No.
When you saw the tags, did that concern you at all as the president?
When he saw the tags as in the photographs, or when he saw that there were tags hanging down from it when he last saw it a few months ago?
When you saw it personally a few months ago, did those tags concern you?
No.
Did you take any action after visiting the jockey pump?
No.
Why did you visit the jockey pump?
We had an issue with an alarm, and we called in to see if we could have the alarm turned off. And that's when I walked up to this side of the building. This is when I walked up and I saw the pump when the fire department came and they were looking at the pump.
Did the fire department tell you anything about?
Objection, Your
Jockey
Honor.
pump.
He's seeking hearsay.
Mr. Williams?
Your Honor, I have not asked him to testify to what the fire department said.
Why don't you ask your whole question? Don't answer it, Mr. Powell. Let me hear Mr. Williams' whole question, and then I'll let you know if you can answer it or if Mr. Williams will need to ask a different question.
Did the fire department who came say anything to you regarding the jockey pump?
Mr. Powell, Mr. Tripp, still an objection?
No, he's just asking if the firefighter said anything, not what did he say.
Got it. You understand the question, Mr. Powell? It's narrow.
Yes.
What's your
Yes, you
answer?
understand the question?
I'm sorry. So no.
I'm sorry. Just so that I know there's a lot of questions at you. What are you responding no to?
You said that the fire department say anything about the pump?
Yes.
No.
Okay, so in preparation, when you became president in February, and in preparation up until now, were you made aware of this noise that has been referenced coming from the jockey pump?
Yes, as of recently, yes. I would say, well, yes, this year, yes, I've been made aware of the noise.
Who made you aware of the noise?
The first time that I heard anything about the noise was actually the tenant for 317.
Miss Vanessa,
Yes.
that we were talking about, okay? And you said the first time. Was there a subsequent time that you were made aware of noise?
Yes.
And who made you aware of it the next time?
The owner of that unit, I believe, Simon.
Okay. And what did you do in response to them making you aware of this noise?
We reached out to our property manager to have an examiner come out and see if it was working correctly, and I guess evaluate the situation.
And is that's the property manager that you have now, the Heritage? Is it Heritage that's your property manager?
Homeside.
Homeside, I'm sorry. So you reached out to Homeside to have an investigation done relating to that, correct?
Yes.
Were you aware that the motor, as testified by Mr. Rowland, was moved from its initial location to this new location underneath Mr. Rowland's bedroom? In your investigation, did you become aware of that fact?
No.
So today was the first time you've heard about the fact that there was actions taken to change the original position of the jockey pump and the motor to move it to where it is now.
Yes.
Today, first time you've heard of that, correct?
Yes.
All right. So just to let you off the hook, I just want to be abundantly clear that you, in your knowledge about Mr. Rowland's complaints, those happened before you were even a board member, nonetheless, not just the president, but before you were even a member of the board. Is that accurate?
Yes.
Okay. I have no further questions for this witness, Your Honor.
Mr. Tripp, any redirect for Mr. Powell?
Yes, Your Honor. Mr. Powell, does the association ever set aside money to do routine maintenance on something like the roof?
Yes.
So not every time money is expended on the roof, it's falling in.
Right.
Now, on cross-examination, my learned colleague got you to testify that today is the first time you ever heard of one component of the fire pump system being moved. That predated your tenure on the board, did it not?
Yes.
I have no further questions for the witness, Your Honor.
All right, may Mr. Powell virtually step down? Hearing no objections, Mr. Powell, I appreciate you being here. You're welcome to stay on the session. You're also free to go. Thank you for your time.
Thank you, Your Honor.
All right, Mr. Tripp, I appreciate you and both attorneys for Mr. Rowland being limber here. We're sort of time warping around. We've heard Mr. Powell's testimony. That is part of plaintiff's case in chief as the defendant in counterclaim. But where we are now is unless Mr. Obaseki has another witness to call, who was always ready, and he said there wasn't one, defendant as the counterclaimant has rested in their case in chief. And it is time, Mr. Tripp, if you've got a motion to argue that motion.
Yes, Your Honor. Plaintiff moves for judgment as a matter of law. The defendant's fire pump claim is barred by Vernon Bowdish Builder Incorporated versus Spalding Lake Homeowners Association Incorporated, a Court of Appeals of Georgia decision from 1990, which is cited at 196 Georgia App 370. That is 196 Georgia App 370. In Spalding Lake, a homeowner sued his community association for failing to maintain a lake, which that lake was the community association's responsibility under the restrictive covenants at issue there. The homeowner claimed that the community association's board of directors breached their maintenance obligation under the declaration by permitting the lake's level to drop. The trial court ruled in favor of the community association, and the Court of Appeals of Georgia affirmed that decision. The Court of Appeals held that the community association's maintenance decisions were protected under the business judgment rule and declined to substitute its own judgment for that of the community association's board of directors. And it said, because the homeowner's claim amounted to a difference in judgment concerning the appropriate level of maintenance on a common element, namely the lake, it was not actionable. Here, just like in Spalding Lake, the defendant's claim concerning the appropriate level of noise that the community association should tolerate really boils down to a difference of judgment between the association's duly elected board of directors and the manager of one of its members, namely Community Development and Investments LLC. The essence of the defendant's counterclaim against the plaintiff is that it did not take what the defendant's manager believes were the necessary steps to maintain the fire pump at a noise level which the defendant's manager believes to be minimally acceptable. Under Spalding Lake and its progeny, this is simply not actionable. And I'll quote from the opinion itself. No principle of law is more firmly fixed in our jurisprudence than the one which declares that the courts will not interfere in matters involving merely the judgment of the majority in exercising control over corporate affairs. That legal principle, which has been consistently applied by the Georgia courts for at least half a century, resolves this case. The defendant is inviting this honorable court to substitute its own judgment for that of the plaintiff's board of directors. This honorable court ought to decline that invitation and grant the plaintiff judgment as a matter of law with respect to the fire pump. And I'll now move on to point out that the defendant, acting as counterclaimant, failed to carry its burden of proof on several essential elements of its breach of contract claim with respect to water damage. First, the defendant had an obligation to establish that there was a contract between the parties. This honorable court in the defendant's case in chief was not directed to a single provision of the party's contract, which my client purportedly breached. Furthermore, the defendant failed to establish causation. Under Georgia law, it is not enough that a contract be breached. It is not enough that one harmed by something be damaged. You also have to establish, as part of your burden, that that alleged breach, caused you harm. This honorable court did not hear any testimony whatsoever on that essential element. At most, viewed in the light most favorable to the defendant, you've seen that at some point in 2017, there was water damage to the defendant's unit. And at some point in 2019, the plaintiff made repairs to the roof, which is, again, above the defendant's unit, but there is no causal relationship. And that's really the Achilles heel of the plaintiff's claim. And I'll go ahead and rest now and seek a ruling from this court on both of those independent arguments.
So I'll certainly hear from plaintiff's counsel in a minute, but I've got a couple questions for you. On this business judgment rule, is there, from your research, Mr. Tripp, a limit on that? I mean, it would seem like if applied indiscriminately, that could result in the oppression of the minority. It could be that any objective observer would conclude that open flame outside the door of 217 is a hazard. It's hard to get in 217. My clothes keep catching on fire, but there's this open flame, and the board won't take action to douse the flame. But the board looks at it and says, you know, our reasoned business judgment is it would be expensive to douse that flame. And so we're going to not douse the open flame. I appreciate that that is maybe a bit more extreme than what sure sounded like a loud pump. Where is the balance struck? Because I don't believe the business judgment rule, number one, I know it's what the case said, is like the most revered and treasured principle of law in all of humanity, even though that's what courts like to say way back then. But what's your view as to how we balance that?
Right. So first, I'll point out, as I must, that that's not this case. But applying the law to that case, that would go to the reasonableness of the community association's decision. So under Georgia law, a community association is entitled to substantial deference. But like you hinted, it's not unlimited deference.
Okay. And that's what I'm going to cut you short just because we're getting close to 5. I don't know when our Zoom session cuts off, but you're acknowledging that it's not unlimited deference. There is a rule of reason to apply, but that courts ought to be very, very cautious before they wade into second guessing the business judgment of the entity that made the decision.
Right. So,
okay.
And I only have one more witness and I don't expect it to take long. So I just want to make sure that I address this question fully. So under Georgia law, community associations' decisions will be upheld unless they were substantively and procedurally unreasonable. And that's an affirmative defense. The burden is on the other party to establish procedural and substantive unreasonableness.
Okay.
And I would just point to, in the interest of time, that case and its progeny, the cases that cite it for further.
When you say that case, you mean Spalding Lake?
Yes.
Okay. And then as to the water damages, you introduced this concept of breach of contract, which prompted me to jump back to the counterclaim. And I don't see that there's an allegation of breach of contract. So I don't know if you're supplying a theory to defendant or you see it where I don't. Because that doesn't.
So they have to ground the duty in something. They pointed in their counterclaim to the association's maintenance obligation under the declaration. Mm-hmm. So even if they didn't technically call it breach of contract, this is a breach of contract issue. And as such, the party's contract, the declaration, is going to govern that duty and provide for conditions precedent and exculpatory provisions and all the rest.
Got it. Okay. So I don't know if it's going to be Mr. Williams, Mr. Obsecki who wants to respond to this, but I am ready to listen.
All right, thank you, Your Honor. So really quickly, first, I would like to address this idea of the business judgment rule. And the Supreme Court has made clear that this business judgment rule does not preclude claims that when a board of directors does not act with what we would refer to as ordinary care. We are talking about a system that there is no question that the responsibility for the maintenance of this jockey pump belongs to the association. That is not in dispute. There is also no question that the ordinary care of this system would not have a unit's bedroom shaking, as you heard in the testimony from Mr. Rowland. There is also no dispute that Mr. Rowland made the association aware of this issue on several occasions, even with a letter from his counsel at the time to make complaints about this as early as 2015. There's also, as Your Honor was able to see, and one is able to use common sense, that we saw on the jockey pump itself tags from the fire department that spoke to the condition of the jockey pump.
Objection. None of that can come in for the truth of the matter asserted.
Right. So we got to be careful, Mr. Williams. I saw the tags as well, but we don't have any testimony that those tags are still there. I did hear Mr. Powell say, I saw tags, but are they the same tags? Don't know. We also don't know what those tags were all about. It may have been that the pump was painted the wrong color. Given the area of law in which you practice, you know that inspectors can hang you're not in compliance for a billion different reasons. So
my point here, though, Your Honor, is not necessarily what the non-compliance is. That to me is not necessary in this situation. The fact is that the board was not using ordinary care to correct whatever it was. And it is also, there's also evidence that has been entered that the property manager at the time had conversations with Mr. Rowland via email regarding making some adjustments to the condition that was originally complained about. Remember, we talked about this huge cut hole that was then where the motor was then installed to be moved from where it was to being adjacent to Mr. Rowland's kitchen to now being placed underneath his bedroom where it shakes. So that evidence has been entered. And this is not a business judgment rule as to whether or not the association under the association's contract, which I agree with Mr. Tripp, this is a breach of contract claim, but there is no dispute because that contract has been entered into evidence. We are not required to point out to the court a particular section. The entire contract is now admitted to evidence. The presence of that maintenance section that says very clearly that the association has these maintenance obligations, they cannot avoid those maintenance obligations by simply saying, we don't feel like we need to be doing that. A hole in a roof, moving on to the water portion of this.
Objection, Your Honor.
hold on.
It's not in the record that there's a hole in the roof. That's not supported by the case in chief.
Okay.
Well, it has been supported by the evidence that was the testimony from Mr. Rowland that the roof had to have repairs.
Okay, I hear you that, but just don't get specific about, was it a hole? Is it that there's a seam has come about? We don't know what exactly is going on with the roof, but res ipsa loquitur, there's water coming into unit 217. So there's something not working with the roof. I hear you on that. Don't want us to fight about, is it a hole or a mole or who knows what?
Well, there's an opening, fair to say, that somehow water goes down 2 levels.
Objection, Your Honor. We haven't heard where the water came from. Nobody testified to where it came from. All we know is that it got there. For all we know, the owner of the unit above, just based on the case in chief, filled the bathtub up and just kept the water on. We just don't know what caused the damage.
I understand. I agree. I think that's where we are. We also know that there are concerns about the roof, but there has been no evidence that links roof of third building issues to water in 217.
Yes, Your Honor. What we do also know is that the evidence and testimony support there was an insurance claim. That insurance claim was paid. Therefore, the court is allowed to take that into consideration in viewing this evidence in light of the non-moving party here is what the standard would be, is that there is evidence sufficient to state that there is a reasonable person can conclude that the evidence has been presented, that there is this obligation on behalf of the HOA, that the evidence shows that there is some fault because the way things are supposed to work, they are not working. No ceiling and the flooring that we saw in the photos has water on them when things are working as they should. And the biggest thing is that Mr. Tripp alluded to, and I think it may have just been maybe he just misspoke, but when he said we have not established a contract, but the covenant has been admitted, the covenant
what I heard him say, so we don't have to go around in circles, is that there's not evidence that the COA, that plaintiff breached the contract, not that there is no contract. I asked him about the contract. He said, no, it's there. It's the declaration. It's in that. This is the only agreement that anyone could point to that would obligate the board or the Condo Owners Association to have to do anything in connection with your client or vice versa. That's their agreement.
Correct. And that is the agreement. And Your Honor, what we are here about is to determine, for this court to determine the breach and the damages. And we have provided evidence for the court to be able to consider whether or not that breach occurred, and if so, the damages that resulted from it. And at this stage, Your Honor, I believe that this motion as a judgment, as a matter of law, should be denied. It is inappropriate. There's more than sufficient evidence for any trier of fact to conclude that there has been a breach and that damages are due to my client.
Okay. Mr. Tripp, my thought is, and we actually have Zoom bandwidth a little while longer, I was able to confirm. You said you have one more witness and it's a witness who would not take very long. Why don't we just flesh out the full record? I'm not comfortable ruling right here based on your motion, not because it's not compelling, but I just as soon get the last bit of evidence and then close things out, let you guys go your way, and I can take the time I ought to take on this important matter in sorting out how it ought to resolve.
That's perfectly fine, Your Honor. And I'll now call Kenneth Baggs.
Mr. Baggs, you still with us?
I'm here.
Great. Here comes the deputy to swear you in.
Okay.
Raise your right hand. Do you swear or affirm that the testimony you shall give to the court is the truth, the whole truth, and none but the truth?
I do.
For the record, can you please state and spell your first and last name?
Kenneth Baggs, Kenneth. BAGGS.
Mr. Baggs, what is your affiliation with the plaintiff?
I'm their former community manager.
What does community manager mean?
It's community association managers.
Meaning you work for the
Former
property
property
management
manager.
company, or you were on the board like Mr. Powell is?
No, I work for the property management company, Homesite
Okay.
Management.
And when were you the plaintiff's property manager?
From August 2019 to October 2020.
And did the defendant ever alert Homeside Properties, Inc. of his alleged leak or flow?
No, did not.
How do you know that?
I went through email records and did not find any communication from Mr. Rowland regarding a leak.
And you searched diligently all the records you had available to you.
That's correct.
And did
Mr.
those-
Baggs, you were the property manager from August of 2019 through October of 2020.
That's correct.
Homeside Properties. If Mr. Rowland would have made a complaint or raised a concern with a property manager at that community in September or October of 2017, would that have still been Homeside Properties, or is it a different property manager?
That was a different property management. I believe it was Beacon Management at the time.
Okay. 2, would your search that you diligently conducted enable you to look further back in time than the August 2019 start of your tenure?
I would not have access to their emails through Beacon's emails.
Okay. So when you say that you found no evidence that Mr. Powell made any complaint or raised a concern or an alert, I say Mr. Powell, I mean Mr. Rowland, that all would be during that window while you worked there, not before it.
Correct, but I did look at Beacon's records that was transferred to us, which had invoices and such. I did not find any work related for a roof leak for Mr. Rowland's unit under their
Okay.
what was paid or invoices that were paid for that work.
Mr. Baggs, when did you first become aware of the defendant's alleged water damage?
It's through the counterclaim that received through your office.
And what did you do on behalf of the plaintiff when you became aware of the defendant's alleged need for maintenance?
Did contact a contractor to assess the roof for any damages, to contact Mr. Rowland to review his unit.
And what happened with that?
To my knowledge, there was no entry made into Mr. Rowland's unit. So that I don't believe any that they could get in to see where the leaks were at. So no work was completed.
But you did hire a contractor who attempted to inspect the premises.
That's correct.
Objection.
What's the objection?
Well, he was offering something, he was offering contrary to what the actual witness had said. The witness had never, until he just answered that question, suggested that the contractor attempted to make.
Okay. Got it. Your objection was to the question, not to the answer.
Yes, Your Honor.
Okay. All right.
Was the contractor able to enter the premises to inspect the alleged water damage?
Not to my knowledge, no.
Your Honor, that concludes my examination of this witness.
Mr. Williams?
Well, I think the court has made my most pressing argument in that, Mr. Baggs, you do not know why, if the contractor attempted to contact Mr. Rowland, you do not know why he was unable to enter
No, I do not know why.
And do you have any firsthand knowledge that the contractor actually reached out to Mr. Rowland?
I had no firsthand knowledge of that, no, sir.
And not to be redundant, and I apologize, but I just have to make sure that I have this correct. You began in 2019 and you ended in October of 2020.
That's correct.
No further questions, Your Honor.
All right, any redirect?
Just one question. So despite not having personal knowledge, you did have access to the prior manager's records in making your search.
That's correct, yes.
Okay, that's it.
Your
All right.
Honor, I apologize, Your Honor, if you would offer me one quick recross point because of that last question.
Sure.
When the court asked you, Mr. Baggs, if you had any access to the previous management company's records, did I hear you correctly that you did not have access to their internal emails?
That's correct. Yes, sir. I'm sorry.
So just for clarity, if Mr. Rowland contacted the previous management company through email, you have no way of knowing that for certain, correct?
That's correct.
All right. Thank you, Your Honor. No further questions.
Mr. Tripp?
Yeah, so I think they should, I don't have any further witnesses.
Okay.
So
So
I guess
Mr.
they
Baggs
should-
is free to go?
Yes, Your Honor.
All right. Well, good. Do you have any other witnesses, Mr. Tripp?
No.
All right. Any rebuttal, Mr. Williams or by Ms. Rivers, Mr. Obaseki?
If we can, let me have a quick confer with my co-counsel, just through a message real quick, Your Honor.
Sure.
That question. Your Honor, if I, one second, I apologize. Your Honor, we have no rebuttal.
All right. Then the evidence is closed. Is there anything, Mr. Williams or Mr. Obaseki, you want to say in summation in support of your case?
Yes, Your Honor, if you would allow me, I'll try to be very brief. But what this case, Your Honor, is not a complicated case at all. This case was brought by the association for recovery of HOA fees. And that is because the covenants requires Mr. Rowland, whose company is the owner of Unit 217, to pay association fees. And as the court has found, those association fees were not paid, and therefore there was a breach of that covenant. It cooks both ways, Your Honor. The covenant that also governs Mr. Rowland's conduct also governs the association's conduct. The association has a maintenance obligation, and that maintenance obligation is to ensure that those common areas are maintained properly so that they do not negatively impact.
Objection, Your Honor, that's not what the contract says. It's in good repair.
So you don't need to object during the summation. When it's your turn, Mr. Tripp, you can let me know that you read it in a different way.
Thank you, Your
Thank you,
Honor.
Your Honor. So the obligation to maintain those common areas is exclusively with the association. And in fact, Your Honor, that same covenant articulates that if a owner even attempted to cross those lines and to make a correction on something that belongs to the association to do, then they are not entitled to even be reimbursed for those expenses. Your Honor, that clearly would put everyone on notice that the association has this obligation and it's theirs alone. And in this case, they failed to do so. And their failure to do so has made unit number 217 uninhabitable. And the complaints that have gone on, not only from Mr. Rowland, but from others in that building, clearly show that they have been aware of this since as early as 2015, as the evidence shows. And this was not something that was present at the time Mr. Rowland first occupied the property. As he testified, he moved into that property when he first bought it. He stayed there for a couple of years, or a year and a half or so. And after that, he rented it out. And it wasn't until then that this issue began to fester. And so this is not the routine operation of the Jockey pump, as counsel had attempted to allege. This is something that is not operating as intended. We would ask that the court takes due notice that Mr. Rowland even attempted to mitigate those damages of not being able to have a tenant by moving into the property himself. As he testified to, he has 2 units, 209 and 217. He left 209, tried to move into 217 because he figures, hey, maybe, this is not something that normal tenants can take, but maybe I'll be able to accept it and then I can rent out 209. He couldn't even stay in there for a few days, Your Honor. And so this is not just, a sound that's going on. Testimony was given that this was something that happened every 45 minutes to an hour and lasted, upwards of 3 minutes. So every time throughout the day, 24 hours a day, you have this sound going on, the unit shaking, and no one wants to live in that. Their quiet enjoyment of their property from the owner's perspective and from any prospective tenant's perspective, which I don't want it to be lost on the court that this property was purchased through an entity which had the intent from the very beginning of the purchase to at some point be able to rent this property out. And they have done so, as testimony gave, for at least 6 years before it was just incapable of continuing on because of the Jockey pump. We also, Your Honor, the court is allowed to consider just the common sense of it all. You have this water just leaking in from a unit. There is no obligation from this unit owner to make this repair. When the impact is happening to this unit from water coming out of the walls, coming through the ceiling, and you have testimony and evidence from the HOA's appointed property managers themselves talking about the roof and the repairs. And I would point the court to those exhibits that were entered into evidence. And that's not the Mr. Rowland's testimony. That's evidence coming directly from the property managers appointed to oversee all of the day-to-day operations of the HOA. And we know they have the authority. We heard it from their current president. Current president himself testified to the fact that that they rely on the property managers and the experts in those companies, that although, I guess they've had to change several times, I'm not sure why, but they've changed multiple times over these years, property managers, but no one involved for the time period that we are speaking of, they provided no one to testify to that time frame. Everyone who they brought, the current president, he's only been president since February of 2021. If they wanted to really, speak to whether or not there's been no notice or no one who should have known was ever given any proper notification, they would have brought the president who was president during this time of this period that we're talking about. The property manager, I'm sure Mr. Baxter's a great guy, but he wasn't the property manager with relevant information for the time period that we're speaking of. Now, Your Honor, it should be no favoritism here. The same covenant that Mr. Rowland was duty authorized to abide by is the same covenant that this HOA should be abiding by, and they failed to do so. And because of that, Mr. Rowland has incurred damages, and those damages stem from his inability to rent out the property. That property currently continues to remain vacant, and rent rates, he testified to, he was collecting at least $900. He had to reduce it down to $825 to allow the tenant because of these issues. But current market rates, Your Honor, won't even go into. But the other point is that he had a deductible from the water leak and damages that he incurred from that. And Your Honor, we only ask that there be equity and fairness in the enforcement of this covenant document, and that both sides be held responsible for what their obligations and duties are. In this case, the HOA, the Condo Association, has failed, and we would ask that the court grant Mr. Rowland damages for the Condo Association's failure to maintain the property as it's required to under the documents, the governing documents. Thank you, Your Honor.
Thank you, Mr. Williams. Mr. Tripp?
Your Honor, I'll begin by pointing out that this is a breach of contract action. And one of the essential elements of a breach of contract action under Georgia law, you have to allege and prove fulfillment of all conditions precedent. During the the plaintiff's rebuttal case, Your Honor was read the condition precedent that the defendant failed to satisfy. He did not present evidence during his case in chief that he notified the plaintiff of his problem. During our rebuttal case, Your Honor heard evidence of the association's response when it first found out about the alleged water damage, which came in the form of this counterclaim, which the defendant illegally filed. My learned colleague is right that this case needs to be decided by the terms of the party's contract, the declaration. What does the declaration say about filing a claim against the association? It says that there are certain things you have to do first, and during their case in chief, they did not prove compliance, let alone substantial compliance at all with that condition. During our rebuttal case, and again, the burden of proof is on, but during our rebuttal case, we pointed to absence of evidence of such notice. So not only did Your Honor not hear that the association was notified during the case in chief, Your Honor actually heard evidence of a lack of notice during the rebuttal case. So for that reason alone, the defendant's breach of contract claims fail. Going back to the argument, I'm not going to beat it over the head. Going back to my main argument on judgment as a matter of law. They cannot establish breach when it comes to the fire pump, because in our rebuttal case, we presented testimony from the current board president that the association reasonably relied on expert guidance. They treated the defendant fair procedurally. As soon as they heard word of the alleged problem, they sent someone out there to take a look and reasonably did not fix something that wasn't broke. And that goes back again to their burden of proof. They had a burden to show that this fire pump was malfunctioning. Your Honor, they could not even tell you how loud the fire pump is. All they had was a video, which is not reliable. They did not go out and record it with reliable electronic devices. They couldn't tell you how loud a fire pump is supposed to be, let alone how loud this one actually is. I mean, I can make a video loud doing this. That's not competent evidence. It's maybe some evidence that the pump is loud, but it's far short of the burden that they bear on breach of contract. I'll go back to no causation. We heard no testimony whatsoever, a complete lack of evidence linking the defendant's alleged water damage to any failure of any kind of the association to do anything that it's required to under the documents. That's fatal to their breach of contract claim with respect to the water damage. You have to prove causation, and you also have to prove damages. And under Georgia law, it's well established that you have to prove your damages in a breach of contract action to a reasonable degree of certainty. Your Honor heard nothing that would satisfy that standard here today. All Your Honor heard in terms of damages is that the defendant paid a premium to get some water damage corrected. That doesn't tell you a whole lot. They didn't submit any extrinsic evidence. We don't have any receipts, no invoices, no bank statements showing within a reasonable degree of certainty just how much this alleged breach caused in terms of damages. And I'll also go back to something that you did hear in the case in chief. You heard that this defendant leased that particular unit for over 6 years. What does that tell you? It tells you that the problem wasn't that bad. If it was, as he's arguing, which he did not prove, if it's so bad that the unit is just uninhabitable, that doesn't make sense. 6 years? 6 years living in an uninhabitable unit. That's not credible, Your Honor. And I'll end with this. They failed to show mitigation. Now, my learned friend in his closing argument hinted at mitigation, but we didn't hear any concrete, credible evidence of that. We don't have any evidence in the record of the defendant listing this unit for rent. We don't have any evidence that repairs were made to address this alleged water damage. All we know is that a claim was made and that it was partially paid. We don't have any evidence that those funds were put towards repairing the unit. So, Your Honor, I'm going to ask that you grant my client judgment in this case and close.
Your Honor, if I can be so entitled to have the last word here.
Sure. As the structural plaintiff here, you can have a couple minutes before we wrap up.
Hopefully I don't even take that long. Your Honor, counsel in his statement continues to talk about this alleged condition precedent to bringing action. At the same time, counsel ignores the fact that this action was not initiated by our client, that our client under the law would have had to bring its counterclaim once he was presented with this action against him, against the company by the HOA. There is nothing in the covenants that would suggest that our client would be prohibited from bringing a compulsory counterclaim to attack and to rebut the amounts that the HOA were claiming were due to it when our client had these claims. So this notion about a condition precedent not being met is improper, and it would almost go against, it would definitely go against the law and almost go against common sense. There's the suggestion that there was no notice given. Well, you heard testimony, Your Honor, from Mr. Rowland, and in that testimony, you heard Mr. Rowland, acknowledge that they ignored him over and over and over again. They ignored him so much he had to go and get an attorney just to send him a letter, and they ignored that. And when they finally tried to do something, their action was to make the condition even worse. They took the motor and they put it underneath his bedroom flooring. So the idea that that they were not put on notice so they could make a reasonable attempt to make a correction, Your Honor, that just goes against the evidence that's before the court. Talking about mitigation, and he suggests that because a tenant was willing to work with Mr. Rowland at a reduced rent, Your Honor, let's not ignore the fact that that the testimony in the record states that in order to get the tenant to stay through this extended time, that rent was reduced. And not only did he reduce the rent, but again, Mr. Rowland attempted to find a different solution by moving into the unit himself. And he could not bear it. So, Your Honor, at every step, our client has made efforts to get the association to comply with its duties and responsibilities under the covenants. And they have failed to do so. Your Honor, this is, again, not a difficult case at all. They have an obligation, they failed to meet that obligation, and as a result, our client suffered damages, and we're asking this court to enforce that covenant and to award Mr. Rowland the damages in which he is rightfully due. And that is, as we have calculated, and using on a very conservative basis, Your Honor, my client was not being unreasonable, was not being greedy here. He said the rent at $900, since it has not been rented since December of 2020, and from January 2021 to current, that is the period of time that he seeks damages for, and also merely for the deductible that he had to pay out for his insurance that covered the water damage that was the result of what my client testified to be maintenance responsibilities that were neglected by the condo association. My client did not seek the actual portions of the damages that his insurance covered. That didn't seek that, didn't ask for that. So, so we would ask this court to, again, hold the association accountable, as this court has held Mr. Rowland accountable for the payment of assessments. Mr. Rowland acknowledges that he believed before getting counsel that holding those assessments were appropriate for what he believed to be the association's failures at that time. And the court properly acknowledged that, no, there is no defense against paying those properly due assessments. Same goes here, Your Honor. There's no defense here against not covering the maintenance duties that the association has. We cannot leave homeowners out to dry when the associations, any association, simply neglects doing those things that it is obligated to do. They must be held accountable just as the unit owners are held accountable for the payment of assessments. And with that, Your Honor, I rest and thank the court for its time in this process.
Well, you're welcome. And Mr. Tripp, you're welcome as well. All of you, appreciate your time in this. I will take this under advisement. I've got the exhibits that were admitted and the other materials that are in the record. If I have any questions as I work through it, Ms. Niles will send an email out to counsel for both sides, even though the question may be for Mr. Tripp or it may be for Mr. Williams. Everyone will get the question and should feel free to chime in. I typically don't ask for post-trial briefs. I might simply say, hey, you've got a couple days to find a few cases that support notion X. Then all you need to do is send us the citations. You don't need to write a whole brief. And we'll take it from there. Mr. Williams or Mr. Obaseki, anything else procedurally from your client's side?
No, Your Honor.
Mr. Tripp, anything else from Cityside's side?
No, Your Honor.
Okay, well, thank you everyone for your time. Have a good what's left of your Thursday, and we will be in touch.
Thank you.
All right, bye-bye.